yourself a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And one is standing by for you right now. David Whiting, your talkback lawyer, is in situ somewhere in a lovely leafy suburb in Melbourne and ready to take your calls. 1300 222 774. David, good morning.
Good morning, Virginia.
Nice to hear from you again. Did we have any homework from last week?
No, we had... Well, you did give me a job to do. I had to go and find a COVID-19 puppy, and I must say that I failed.
Oh.
We tried a couple of Zoom meetings with puppies, and I just didn't hit it off properly.
Now, you can't really connect with a puppy over Zoom.
Yep.
You just don't want your slippers and your shoes all chewed up by a...
No, we had two dogs that managed to destroy quite a few garments.
Yes.
So, no, I don't want that to happen again.
No, look, I have a feeling you're going to resist that particular urge. But we were talking, I think, about last week, weren't we, about judge-only trials because of COVID-19. What's happening there?
Well, they've announced, the Magistrates Court, the County Court and the Supreme Court have all announced rules for, County Supreme for judge-only trials. They've announced the processes and how applications are made. So I would expect that they would be getting underway fairly quickly. I also note that in New South Wales, judges' tend to have fairly good holidays,
Right.
are all being postponed so that they can get through as many trials as quickly as possible.
No, that's because they can't actually fly away overseas because there are no flights and you're stuck at home.
That's clearly part of the problem, but yeah.
Sorry to be so cynical about it all.
No,
But
no,
yes,
that's perfectly reasonable.
there also is a great deal of work to get through. So a judge-only trial if the prosecution and the defence agree, correct?
No, it's an application made by the defendant.
By the defendant. So it doesn't matter what the prosecution says?
I think the prosecution will have some say in relation to process, but essentially the anticipation is that the application will be made by the defendant.
Okay.
Because it's the defendant who's giving up the right to the jury.
And you've also dug up some info we need to know in these COVID-19 times about leases.
Well, a couple of weeks ago, the government passed a 400-page piece of legislation in, I think, 3 hours with that amendment. And there are a whole series of provisions relating to the rights and obligations of landlords and tenants under residential leases. They've also, on last Friday, they produced what I'll call a Bible as to changes in relation to commercial leases.
Right.
So, and there was an interesting story, I think it was in today's paper or yesterday's paper, that said that let's assume that a landlord and a tenant want to bring the lease to an end. The suggestion is that the current legislation doesn't allow that to happen. So it's interesting. Evictions are now outlawed for a period of 6 months from the 29th of... I'm not quite sure what the effective date is. The legislation was formally commenced on the 25th of April, but the legislation says it's deemed to have commenced on the 29th of March. And there's a provision in section 615 of the Act that says that these particular amendments are repealed 6 months from commencement. So is that from actual commencement or deemed commencement? So anyway, that's just a lawyer talking.
That's why we have you here, so a lawyer can talk. Just before we get to calls, and our number is 1300 222 774, just interested in your view if you were the lawyer called to represent Dean Laidley, who is behind bars, of course, at the moment right now, having been charged with some stalking and other offences. And his photograph turned up on the front page of the paper as it did yesterday when he was in the police station. What would you have said and done?
I would be outraged, as the police are outraged. But in the end of the day, the question will be, will it affect his ability to get a fair trial?
And do you think there are open questions about that?
No, I don't. I think the answer is that there will be a fair trial. It's part of the modern world, Virginia, is publicity. And if you like, the ability so that picture will live on the internet for 1 million years. And so we get judged not just before a court system, but also in the community in which we live, and unfortunately, the resources in the internet are such that you never actually get the complete picture. You just get a snapshot from which you may or may not form the right opinion.
David Whiting is with you to answer your questions this morning. If you'd like to grab a slot, 1300 222 774. Phil is first up in Warrnambool. Hi, Phil.
G'day, guys. How's things?
Good, thanks.
Hey, once restrictions lift and we can have a party, if I put on the alcohol and charge people $50 a head to pay for it, is that considered still selling alcohol, or?
Yes.
It is.
Yes,
Yeah.
but on the other hand, because what you've done is you've gone and bought the alcohol and you told somebody your share is $50.
Yep.
Right. On the other hand, if everybody gives you $50, if there's an agreement in advance that each of them will put in $50 and you will go and buy the alcohol, then you're buying it. You're not on selling it. You're purchasing it as agent for them.
Oh, beauty.
Do you see the distinction?
So you need to get the money first, Phil.
Yeah.
Well, you need to get the agreement for the money first. And can I say, Phil, we still have social distancing rules.
Yeah. Think about
Right,
it.
so make sure it's a small party, and go for upper shelf stuff rather than volume, will you?
You can't give that, David. That is beyond your remit about
Okay.
what Phil purchases.
I just
Phil,
was worried
you're
about
planning your party pretty early, aren't you? We're not out of lockdown yet.
Oh, yeah, but I'm thinking the Pirate Pub, if you know what I mean. Open it up in my shed and, $50.
Oh,
membership.
you watch it,
no,
Sunshine, and you
no,
can't
Phil.
go. David, I'll hand this to you.
No, Phil, the answer is no way.
Thank
It
you.
says everything. You've got social distancing issues. You've got a million problems in what you're proposing.
No, Phil, I'll dob you into the cops in Warrnambool if you do that.
What about my cardboard poker machine?
Yeah, well, now I'm just going to say goodbye to you. Nice to hear from you, I think. Just watch yourself, mate. Straight and narrow for you. Noel is in Vermont South. Good morning.
Good morning, David and Virginia. I am doing my enduring power of attorney using the Office of Public Advocate form, and I'm happy to appoint my 4 adult children as my 4 attorneys to act severally, but I'm trying to understand whether there's any practical reason why I shouldn't appoint them severally and jointly.
None at all.
Okay.
Jointly means they must act together. Jointly and separately means they can act together and they can also act individually. So if you're prepared to give them the power as your attorney severally, then just say so.
Yep. And severally and jointly.
It makes no difference. Makes no difference, Noel.
Because they need to cooperate a lot to act jointly under that arrangement, don't they?
No.
Well,
If you make them joint and several attorneys, then the answer would be they can act together, but they can also act individually.
yes, but to act
Right.
together, they've sort of got to get together and say, we're going to act together.
Yes, but remember they can do it one way or the other. If you, in your instrument, in your document,
Yes.
they could each get a checkbook, or all 4 of them could sign a single check.
Yeah.
They could do it either way.
Do they get along, Noel?
Yeah.
They
No
do.
problem. Yeah.
Okay.
Yeah.
Makes no
I just couldn't
difference
see
then.
any practical difference at all, that was all. But
No,
I thought
there's
there
a
might
difference
be a
between
hidden-
severally and jointly, but there's no difference between severally and jointly and severally.
Yep.
Yep.
Great, thank you.
Clear as day. Good on you. Thanks, Noel. Vanessa is in Rosanna. Good morning.
Oh, yes. Good morning. David, just wanted to ask you, just calling on behalf of my young daughter, just currently works at has a part-time job. The employer notified her recently that she's been terminated, and there was no notification in writing or verbal or meetings or anything of that nature. She works several shifts as a lifeguard, and she was told the reason why she was terminated because the term they used was she was a irregular casual. We've looked up the meanings of this word. It's a little bit conflicting as to the understanding, but Well, just wanted to know where we move forward from here, David, in the sense of not being notified whatsoever once you made inquiries. Thank you.
Vanessa, was she a part-timer or a casual?
Casual, David.
Okay, well, a casual has, at law, no entitlement to another shift.
Right.
Now, a long time ago, I worked in a bar at the airport, and all of the staff rosters were on a big pin board, but nobody's name was written on the board. Everybody's name was written on a piece of paper on the board that was pinned to the board, and that's the way they argued that everybody was a casual. So, but as a casual, you are not required to be given any notice that your job is coming to an end. You just simply don't make it to the roster.
Right. Okay. So no notification of termination, or there's no more shifts, and that's the way it goes. Right. Okay.
Well, it's more that what I'm telling you is that I'm not going to give you any more work.
Right. Okay.
You're just like now permanently off the roster.
Okay.
Whereas
okay,
if you were even a permanent part-timer, there would be the expectation of notice.
Vanessa, can I just ask, for how long was your daughter a casual at that workplace?
On around about 24 months, and she was sort of working on average between sort of 2 shifts a week on a casual rotation basis. It wasn't a permanent day or time. It was
it's possible she may be eligible for JobKeeper because casuals of more than 12 months employment can apply for those, but then she will have to do that in conjunction with her workplace. And if they're not offering her any more work, David, do you think she'd fit that requirement?
Well, you can get the JobKeeper even if there is no more work for you. So I would be going back to the employer. But it has to be paid
through the employer.
But the employer you need to consent to the employer making an application on your behalf. The employer then makes the application. If you are successful, then the amount you get is $1,500 a fortnight, regardless of whether there's work for you or not.
Yeah, that's how this whole process started, because she made that initial inquiries in reference to pertaining to the employer. However, they advised her that she's ineligible because effective September of last year, she was terminated. But she said, but I was actually rostered on and worked after the date that you're telling me I was terminated. So it's a very conflicting grey area. We're just a bit unsure.
Well, sorry, but she wasn't working for them on the 1st of March. Is that right?
Of this year?
Yes.
No. She hadn't received a shift on the 1st of March. No.
Yeah, okay.
No, so the JobKeeper eligibility, was she on the roster on the 1st of March? Not necessarily working on March 1, February 29, March 2. It's really, was she within the group of employees for that pay run? So if she last worked last September, October, but hasn't worked since, then no, she wouldn't be eligible for JobKeeper with that employer.
Okay, I'm sorry to let you know that. Thanks so much for calling in, Rosanna. Vanessa, good to hear from you. We were talking before about wills and people giving powers of attorney. Liz has called in from Ballarat with something a little bit along those lines. Hi, Liz.
Good morning. Thanks for the show. I enjoy it. What is the point of writing a will when it is going to be contested and changed? I know it's a very general sort of a question, but I've had experience with this. In the family where a will has been done, gets contested, and in the end you lose out. Not me personally, but a family member.
Okay, Liz, let's start at the top. Over 99% of wills proceed without objection. Over 99% of wills are given effect to without a challenge.
That's
so
amazing.
Clearly for that 99%, your argument doesn't work because they are not contested.
Oh, well, I never
for the other ones that are contested, the presumption, someone comes along and says that the person who has died had an obligation to me that they did not discharge by their will. So they should have provided for me, or they didn't, or they provided but it wasn't adequate. And then someone assesses whether that's right or wrong, or all of the beneficiaries agree with an outcome. So That's the process. It's you're not
If
allowed. I'm sorry.
If I write a will and leave a child out of the will, a child that we're estranged from, do they have a right to come back and contest the will?
Yes, they do. Yes, they do.
If I leave-
But also,
if I leave-
Julia, sorry, Liz.
Yeah, yeah.
It's also true to say that if you were to exclude your family in their entirety and leave it to a charity, then all of your children would be able to challenge your will.
Right. Can you then choose how much you give each child? Is that going to be contested?
It can be contested. I don't know the family that we're talking about, but it can be contested. The only way to ensure that no one challenges your estate, Liz, is to give it all away before you die.
Great.
All right?
I think we'll spend
But
it.
that would be
Thank
proving
you
the
very
point,
much.
wouldn't it? All right?
Well, it's yours. You're entitled to spend it, or indeed organise all those bits to be handed away while you're still alive and get to enjoy
Yeah,
the
but you
pleasure
then
on
might have
people's faces.
Centrelink problems.
Sorry?
Yes. You might then have Centrelink
Yeah, you
problems.
may indeed.
Liz,
Thank
the
you.
issue...
Good luck, Liz.
If you want to make different decisions for different family members, then you should reduce to writing, not necessarily in the will, but why someone's in or out, or why you've made differential payments.
Yep. And
Thank
maybe
you very much.
Explain that. Good on you. Thanks so much, Liz. Just who am I going to? Just 1 second. We had a part. Yes, Ashley is in Moorabbin. Let's hear from Ashley on their particular query. Hi, Ashley.
Good morning, David and Virginia. About 2 weeks ago, I had, I have a street frontage in front of my house with a double garage in the middle of the frontage. And there's a gum tree that drops a lot of gum nuts. And that's where I normally park my car. So this time I had moved my car about a length back, which went into the front of the garage. And I was cleaning the gum nuts. So I went to the house to get a broom and all this, and while I was there, the council came and found me $99 for parking in my driveway.
They actually charged you for parking in the road reserve
Well,
because you only own inside your fence.
That's right, yes.
You
But
have no right to park outside your fence other than on the roadway.
Yeah, but I didn't really park there. I'd moved back to come and clean the gum nuts from the street.
I understand that, Dave, but you also then left the car, Ashley, you left the car unattended in the road reserve. I have all the sympathy in the world for you. I've done the same. I've got a ticket.
Did you get fined, David?
Yes, I did.
Ooh.
Not every time I've done it, Virginia, but once I got fined. And the answer would be you're not allowed park there in the same way as you're not allowed park on the nature strip. You can get a ticket for that.
I wrote to them and explained the situation, and they said that no, you can't decide where to park in front of your driveway and when not to park. In fact, it wasn't parking, but they say now you have you cannot appeal again, and you have either one of the two options, either to pay or go to court. So I was wondering whether it's reasonable to go to court for this or just pay the money.
My view would be you're going to spend a day in court and you're likely to still get fined.
Oh, I see.
Sorry about that.
Okay.
Ashley, I think you might just have to pay the money. Do you remember, David, it was a couple of months back we had a query about a will, an estate that was being sold and carved up, and there was a gun involved. Sam in Geelong has another pistol inquiry. Hi, Sam.
Good morning, all.
Go ahead.
I'm executor of a deceased estate, and I found a pistol. It's not registered. The previous owner wasn't registered. Am I, as the executor, the will states everything must be sold. Am I able to sell that?
The Firearms Act talks about your obligations as an executor. As a general principle, you would need to register it before you could sell it. You can dispose of it to a gun dealer, but there's probably a reporting obligation to the Firearms Registry.
Right.
Oh, you could sell it to a gun dealer.
Okay.
If you tried
all
to
right.
sell it to me or to Virginia, all of us would be in trouble.
All right.
Is it
So,
an antique pistol or a contemporary
it's old,
Yep.
but I don't think it's worth a lot of money. But as I say, the will stipulates everything must be sold. So
one? Would any of the recipients from the sale of the estate care whether they got money for the pistol or not?
probably not.
Could it just be handed
But
in?
you've got some obligations that you need to put in place before you could sell it, Sam. I don't think they're worth the effort unless it's a particularly valuable antique.
So when you say not worth the effort, David, you think just hand it over, just hand it in if the gun shop would take it?
Yeah.
Yes.
To get a pistol licence, pretty involved.
Oh, yeah, you've got to be a member of a pistol club.
Right.
Yeah.
You're going through all of this trouble just for the purpose of selling it?
Yep.
Doesn't sound
You're very assiduous as an executor, Sam. I'm impressed.
Sam's
High
doing the
praise.
right thing.
High praise. Thank you very much.
Well done. Good on you, Sam. And we've got time for a quick last one this morning. Anne in St Kilda, good morning to you.
Oh, hello. I provide a family therapy practice and my landlord won't negotiate with me about reducing my lease, which goes for another 12 months, so I've had to leave because I can't provide counselling services because of social distancing.
Mm-hmm.
I'm not allowed to see anybody in the room, but they still want to charge me for the room, and my business is now closed.
And so your question is?
My question is, I don't know what to do now. I've moved all my stuff out of the room because I can't use the room because of social distancing.
But you're still being charged your rental.
Your landlord can't refuse to negotiate. He might be unwilling to negotiate, but can't refuse.
Well, I've had to move out of the room and remove my stuff because they still continue to charge me rent and I can't use the room and probably won't be able to use it until all the social distancing is removed.
I understand all of those. I'll give you a proper answer next week.
Thank you.
There are regulations which cover it, which were gazetted. So if you look at gazette.vic.gov.au
Yes.
and have a look at the Gazette of the 1st of May, a copy of the residential lease changes you can find there, but I'll give you the proper answer next week.
Yeah, this is a commercial lease.
Yeah, commercial leases are in the Gazette of the 1st of May.
Lovely. Thank you.
Thank you.
Lovely. I hope that works out. So do stay listening next week. And we have a buyer for the antique pistol here. Jack in Ballarat is prepared to buy it. But I don't think I'm necessarily going to put these guys together, David. What do you think?
Is there a fee in this? Is there, Virginia?
No. Well, I'm not taking a fee and you're not either, all right?
Okay. All right. Understood.
Compromises both of us. Great to chat, David. Thanks for the advice.
Thanks.
Thank you. David Whiting, your talkback lawyer there, talking to you from an undisclosed location somewhere in Melbourne.